leader of Dr. Mariano C. Lau, ICI Laboratory, Dr. Dave Marshall, to officially open this series with a welcome remarks and introduce our first speaker. Sir Dave?
Hey, thank you everyone, and good afternoon. And I am happy to see our participants here who've been attending with us since day one, or the first webinar series on the online distance teaching and learning. Today is another day for all of us as we prepared and embrace to the new normal of the online distance teaching and learning. This afternoon, we prepared a set of lecture or webinar, particularly on the intellectual property and privacy on online distance education. Without further ado, let me introduce to you our first speaker. Our first speaker is a colleague of ours in the university and a faculty of the College of Law and a member of one of the lawyers of our General Counsel in the university, Attorney Gas, as I called him. Attorney Gas, please come in and take it away.
Thank you, Sir Dave. Welcome, everyone. Good afternoon. Thank you for inviting me to host or to be one of the speakers for this webinar. It's my honor. So my presentation this afternoon is on intellectual property rights. As we shift more of our delivery of education to online platforms, there are issues of how to make sure that we do not violate the intellectual property rights of authors or owners of intellectual property whose materials we get from the internet or we share in the internet or in our online platform, which is the SILLIMAN online, the sole platform. So let me just share to you my slides. And what I want to do this afternoon is first I will give a brief survey of the law on intellectual property rights in the Philippines. And then after that, we will take a look at how it applies to online delivery of education. Okay, so first, what is intellectual property and what are IP rights? So we have in the Philippines the Intellectual Property Code, and it has been amended several times. And generally, there are 4 types of intellectual property. And these are copyrightable works, trademarks, patents, and trade secrets. In the Intellectual Property Code, there is actually a more expansive list of the types of intellectual property, but generally, they fall under those general 4 types. All intellectual property are creations of the mind. Okay, so if you can imagine, these include articles, essays, anything that is made with the use of our imagination are considered intellectual property. In the context of education and use of learning materials, we are most concerned with copyrightable works. Although in some departments of the university, for example, in engineering, the College of Engineering and Design, and maybe also in the College of Computer Studies, our students or faculty might come up or invent new tools or new machines, and those things are called patentable works, but the designs for those works will also be considered as copyrightable works, although the prototypes and inventions themselves are things that would have to go through patenting. So my presentation this afternoon will focus more on copyrightable works because that's mostly what we will be dealing with when we deliver our online education. Okay. So intellectual property rights are like any other property right. They allow creators or owners of patents, trademarks, or copyrighted works to benefit from their own work or investment in a creation. So these are important rights because they protect inventors or creators, and in doing so, we give them an incentive to be creative and to innovate and to come up with new things for people eventually to enjoy. But at the same time, the intellectual property rights are there in place to balance the interests of the public as prospective consumers or benefactors of intellectual property and the innovator, artist, or creator. So any machine that we use right now, any material that we use in learning, that must have come from someone. And we use that, we enjoy that, we benefit from that. And of course, we don't want to abuse the innovator, or artist, creator from whom we get these intellectual property rights, and without which we wouldn't be able to enjoy many of the technology that we use today. Now, as I said, we are going to focus on copyrightable works in our presentation this afternoon. So what are copyrightable works? Copyrights apply to original works of a literary or artistic nature and works that are derivatives of such. So this is the definition from the Intellectual Property Code itself. And the following is a non-exclusive list of copyrightable intellectual property. Okay, and these are things that we in the university deal with. Okay, so we deal with books, pamphlets, articles, and other writings, lectures, sermons, dissertations prepared for oral delivery, whether or not reduced in writing or other material form. Now that clause, whether or not reduced in writing or other material form, is important because even audio recordings of lectures or even screenshots of PowerPoint presentations, including this one, is considered as copyrightable intellectual property. Okay, the list also includes dramatic or dramatical musical compositions, so that includes musical scores or even musical recordings, works of drawing, painting, architecture, sculpture, engraving, lithography, or other works of art, models or designs for works of art. Now, that last clause there, models or designs for works of art, includes um, impressions made by our architectural students or designs created by our engineering students, and even sketches of created by our art students. Now, copyrights also include audiovisual works and cinematographic works and works produced by analogous works produced analogously. So pictorial illustrations, computer programs, literary, scholarly, scientific, and artistic works, dramatizations, etc. Okay, so this is a non-exclusive list of copyrightable intellectual property, and this list is provided under the IP code to give you, to give the public an idea as to what is included in that list of copyrightable works. Okay, at the moment of creation of a, so when do copyrights begin to exist? At the moment of creation of a copyrightable work, the intellectual property right, the intellectual property is protected right away. There's no need to register or to send or to go to the intellectual property office of the Philippines to apply for a copyright. You don't apply for a copyright the moment that you have written an article, the moment that you have composed a musical score. At that moment, you already have you're already protected by the intellectual property code. Now, in contrast to trademarks and patents, these things need to be registered first with the intellectual property office before you can be fully protected and have the full power of the law behind you in protecting your rights over trademarks and patents. So just to recap, to go back a little bit, trademarks are things like the Jollibee logo or Intel logo, logos that we attribute to a certain person or company, which they use for commercial reasons, while patents are 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 used for inventions or any tool or technology that addresses a particular problem, and which has a commercial application. So, for example, if an engineering student in Silliman University was able to invent a a, a, de- a device that would be able to encourage birds or bees to cross-pollinate and therefore increase the yield of a certain crop, then that technology would be considered as patentable technology. Usually, patents apply to technologies and devices. Okay. So, what rights does the owner of a particular intellectual property have? Okay, so there are two classifications of rights that the intellectual property owner has. The first is economic rights, and the second one is moral rights. Now, the difference is that economic rights are those that you can transfer to another person for economic considerations. These are economic rights that you can contract away. So something that uh, uh, you can enter into an agreement with in exchange for economic considerations like money. For example, an author can enter into a contract with a publisher to reproduce his work, to translate it, to adapt it, abridge it, or to basically, when you want to upscale already your production of a particular book or article, that's an economic right that you can enter into agreement with a publisher. Okay, you can also assign the right to rent out a copy of your book to someone else. Uh, economic rights also include the right to publicly display, perform, or otherwise communicate the work. Now, this is important, and I will discuss this later on when I talk about open access content or public licensing agreements. Um, uh, and that's one way that we are able to enjoy the intellectual property, such as journals or articles of other authors, and use that as our learning materials without having to personally get the consent of the author. Okay, so those are economic rights. These are things that we can that the author or the owner of the intellectual property right can transfer to another person or contract away to another person. Meanwhile, moral rights are those returned by the author, the original source of the intellectual property right, whether or not the economic rights have been contracted to another person. So, regardless of whether someone has the license over an intellectual property, the author always has the right to be cited as the author of that article or copyrightable work. The author is also the only one who has the right to alter the work prior to publication. He also always has the right to object to any distortion, mutilation, or modification of the work. He or she also has the right to restrain the use of his or her name with respect to any work that is not his, hers, or any distorted version of his work. Now, so what about us who are going to use this intellectual property right? What about the teachers who are going to presumably use certain copyrightable works as learning materials in our online delivery of education or online distance learning? So generally, copyrighted work property may only be used, shared, or reproduced if any of the following conditions are present. Number one, and this is the best way, is if you actually get the explicit consent of the author or owner. Now, of course, this is, although this is the best way, this is often the most difficult way as well, because authors are very difficult to contact sometimes, and then sometimes, of course, they may not necessarily agree to the use of their work for whatever purpose that you may have. Um, um, Second is the work is open content or under a public copyright license or is open access or in the public domain. So what do these things mean? Open content refers to things that are by the word open, free to use and to actually take a look at. Generally, um, um, things like journals, you cannot access them easily on the internet. And what somebody has thought of geniusly is to come up with a website. And what they do is they themselves, these companies go to authors, they enter into contracts with these authors, whereby the authors would agree for the company to publicly allow the access to their journal, to their journals, um, and so people can just access the website without having to go to the author themselves. So basically, these websites would be basically acting like a middleman for the benefit of us who will use the learning materials. So so these things, open content, public copyright license, or open access, these are similar things that I will delve more into later. What about public domain? Uh, p- um, Generally, a, the intellectual property owner of a copyrightable work owns the copyrights over his work for the duration of his lifetime and 50 years after his death. After 50 years of his death, then the work enters into the public domain. And when it enters the public domain, the intellectual property becomes basically open to being used by the public or being read by the public. So we have things like the books of Charles Dickens, for example. That's already in the public domain because Charles Dickens has already died almost, I think, 100 years ago. His books, like A Tale of Two Cities, for example, that's something that is easily found on the internet and can be reproduced. The estate of Charles Dickens will not run after you because the works have already entered the public domain. And even the works of William Shakespeare, for example, are already in the public domain. So you don't have to, you know, go to the family of William Shakespeare to ask for permission to be able to produce a play or to be able to reproduce the plays themselves, you know, to photocopy them. So that's the second condition, that you'll be able to use copyrighted works of other people. Okay, the third one is when you apply the principle of fair use. I will delve more into this. I think the principle of fair use is very much important for us educators because the principle of fair use, I think, is designed by our legislators, by the law on intellectual property, so that we may be able to make fair, so that we may be able to use these copyrightable works for justifiable educational purposes. And the last condition is when the copyright protection has expired. And copyright protection has expired. The copyright protection can expire in several ways. One of them is if the author himself waives the copyrights, meaning he surrenders the rights, the economic and moral rights over a particular intellectual property, or when he or 50 years after his or her death. If none of these conditions present, then most likely there is there is copyright infringement. So yeah, I would advise that if you try to include someone's material or copyrightable work as a learning material, make sure that at least one of those conditions are present before we share them to our students or use them in our online distance learning. Now, a note on open content on the internet. I was trying to research on the profile of my fellow speaker here, Dr. Peter C. And I think he'll be able to share more on this later about open content, because I think he has been involved in projects relating to open content. But what I know about open content on the internet is that there are some entities such as Creative Commons, GNU GPL, or uh, uh, the Open Source Initiative. What they do is these are companies or entities. What they do is they acquire intellectual property rights under a public copyright license, and under these licenses, what they do is make intellectual property such as images, photos, videos, and journal articles available to the public. Okay, and so what they do is they pay basically the author or the owners of the property something money, so that and then the authors will then agree that these entities will be able to share these properties on the internet. So if you have stock images, okay, repositories of stock photos on the internet, those are usually made available under a public copyright license. Um, I think the most maybe you've encountered is Creative Commons. Creative Commons, what they do is they make available photos and videos to be able to be used without you having to go to the creators of these intellectual properties and get their consent. Open content refers to any creative work which may be used or modified and or copied without prior permission from the creator or owner. Likewise, some websites offer open access to academic journals, conference papers, theses, books, and monographs, for example, CORE, Directory of Open Access Journals, etc. In either case, so in these cases, you can use and access the intellectual property, but when you copy them or use them in your learning material, attribution to the owner or author is still necessary. And why is that? Because, like I've said before, the economic rights are distinct from the moral rights. Okay, so even if the economic right to publish or give access to the material is free for everyone, the moral right of the owner or author to be cited as the owner or author is still existent. Those are moral rights are rights that are not, alienated by the owner or author. So regardless of whether, regardless of the fact that intellectual property is already open content or under a public copyright license, you still have to attribute to the owner or author of that property of the photo. This is a prevalent problem now in our social media age. Many people share images and videos or content on Facebook without citing who the owner or author is. And although websites like Facebook or YouTube make things easily shareable, there's always that share icon on every post on Facebook. It doesn't mean that you don't have to attribute that content to the owner or author anymore. Okay? You always have to attribute to the owner or author. Now, under the intellectual property code, there are also certain instances when intellectual property is being used, copied, or reproduced, and these are not considered as copyright infringement. So, for example, recitation once the intellectual property has been published, and I think this is already a given. So, for example, when we provide books, we provide books for our students as a reference for their studies. When they read it, and the teacher asks them to recite a portion of that book, then definitely that's not considered as copyright infringement. Quotation also for a justified purpose is not a copyright infringement. So what are justified purposes? Or scientific, literary, religious, artistic, or scholarly purposes, and in accordance with fair use, provided that attribution is made. This is important, provided that attribution is made. So even a snippet of a particular article, when you copy it and include it in your article, you always have to attribute it back to the owner. Now, fair use, this is important one, as I said earlier. Fair use is the use of copyrighted works strictly for the purposes of criticism, reporting, teaching, scholarship, and other similar purposes. So there are this is one of the things that we as educators will have to rely on when we try to, when we do our academic work, whether it's for research or for instruction. We are allowed to copy certain portions of a particular work, as long as we can justify why we made such copies. In several cases, the Supreme Court considered certain factors in determining whether the copyrighted work has been fairly used. And these are some of the criteria used by the Supreme Court. For example, number one is whether the use was for commercial or for nonprofit educational purposes. So if I as a teacher photocopies 100 copies of one chapter of a book, and sell that, and that's the only reason why I made that made those copies, is to sell those copies to my students, then that's not a fair use anymore. But if it's used so that we can make, if we make those copies for the purpose of making that material as a reference for a learning activity, then it can be considered as a fair use of that copyrighted work. The nature of the work is also taken into consideration, and the substantiality of the person used in relation to the work as a whole. So generally, it's not advisable to photocopy an entire book or an entire collection or volumes of a particular work. And the nature of the work is also important, because the nature of the work determines whether or not it's relevant for a particular educational purpose. You don't usually, for example, if you're a teacher of let's say music, you then presumably the copyrighted works that you would include as learning material for that would be related to music as well, not to something that's very something that's not relevant to music. Let's say, like, maybe, I don't know, particle physics. Okay, so those are the things that are considered by the Supreme Court. And lastly, the impact on the potential actual market value of the work. So the fair use principle protects both the economic and moral rights of the owner of the copyright. So this means that fair use is not an excuse for, like I said, for reproduction of entire books, articles, video footage, etc. Now, I have a last note here. The Philippines is actually a member of the World Intellectual Property Organization, or the WIPO. And our intellectual property code includes a reciprocity clause, which extends the protections under our law to any citizen of other WIPO countries. So this means that the fair use provision of our intellectual property code will also apply to content on the internet which were created by citizens of those WIPO countries. So WIPO countries includes the US, EU. So be careful when you take things off the internet and apply the fair use principle, because just because the IP code is a Philippine law, it doesn't mean that the people who are authors, who are foreigners, they're also protected under our intellectual property code by extension of the treaty that we entered with those nations as well. Okay, so now, if you notice in my previous slides, I've always emphasized attribution and citation. Attribution is the act of declaring that a particular intellectual property is owned or sourced from a particular person. And under the Intellectual Property Code, the source and the name of the author must be made whenever we attribute. So both the source, where you got it, and the name of the author, who made the intellectual property. Now, citation is the manner by which we make that declaration. Now, the manner may vary according to our different academic disciplines. Some disciplines use the American Psychologists Association style, or APA, the American Medical Association style, or AMA, Chicago style, and we in the legal profession use the Blue Book citation style. Regardless of what citation style you use, What is important under the Intellectual Property Code to avoid liability for plagiarism or copyright infringement is that there must be attribution to the copyright owner, the source and name of the author or owner of the intellectual property. Now, let's so given what we've just learned about the law on copyright of works and intellectual property, what does that mean for us in SILLIMAN as we shift to online distance learning? My advice is that, like I've just emphasized, is you always attribute even when you're unsure of the proper citation style. So at minimum, both faculty and students, whenever they take something from the internet, should always cite the source and name of the author. For us faculty members, we should also try to encourage students to look for open content, but also instruct them to always attribute to the source and author. Okay, open content, there are many directories on the internet where you can just Google open access articles on a particular topic, and Google usually shows up usually shows websites that you can just click on so that you can have access of learning materials for free, and you don't have to go to the author of a particular article anymore to get their consent for you to be able to use those articles. But as long as you still cite them, you still cite the source and the author. A note here: most social media sites are actually open access. So YouTube and Facebook videos may be shared, embedded, or linked, so they can be used or shared without infringing copyrights. Okay, so such videos can also be clipped or modified for purposes of fair use or commentary, provided there is proper attribution. So we can actually reproduce these videos as long as you observe the fair use principle. It has to be for a legitimate educational purpose. You can't copy the entire video. You use it for to critique or to make a comment on the content. Okay. Now, an issue that has popped up or something that's been talked about recently, because SILLIMAN is not the only one that's transitioning into online distance learning, and one of the issues that's popping up now is that as institutions transition to online distance learning, naturally what has been happening is that the faculty and of a particular institution or an university administration, they have to work together in order to provide learning materials. So there's a question that pops up: who owns learning materials under this context of online distance learning? Under the Intellectual Property Code, the faculty who create course materials like syllabi, guidelines, course outlines, they are the owners of those materials as well. If they use their own journal articles or research output, of course, they are still the intellectual property owners of those articles or their thesis or their dissertations. So that's the default. That's a default position of the law. There is a trend, though, that as learning institutions shift towards ODL, the faculty and the institution enter into contractual arrangements as to the use and attribution of learning materials used for ODL. But this only applies to those materials created by the faculty. But as of yet, as far as I know, there is no policy from the SILLIMAN Board of Trustees stating this. So the faculty are still the owners of the intellectual property that they create for their own courses. Materials sourced from other authors must be acquired by faculty with their consent, or are open access, or are used according to fair use principles, as I have discussed earlier. Content created or submitted by students, for example, their essays, their papers, articles, drawings, etc., are still the intellectual properties of the students. unless although we are a research faculty, we are a research university. As far as I know, the students do not actually contract away their intellectual property rights over their thesis or their dissertation or their MA thesis, things like that. So they are still the owners of those copyrightable works. Although they deposit, I believe every time a student fulfills his thesis obligations for their degree, they give a copy to the library because the library is our repository as a research university. The mere act of depositing it to the library doesn't mean that the students have already surrendered their copyrights over those things. Um, uh, as for our students who are more in the more industrial courses like engineering or architecture or uh, in the computer sciences where they create their programs or invent tools, um, we now have an ITSO office headed by Mr. Austero here, and also Dr. Forster, Janice Forster, our TBI manager, and I think also the Mariano Now laboratory also gives support to our students when they are in need of patenting their inventions or their designs. So that ends my presentation, and I hope to engage with everyone and when we get to the Q&A portion of our webinar. So thank you for listening, and I now cede the floor to Dr. Marshall.
So Dr. Marshall is not here. He went to a appointment. So thank you, Attorney Ganier from the faculty in the College of Law in the Office of the General Counsel here in SILLIMAN University for the very informative discussion about IP and how it can be applied to online learning or education. My brief takeaway from the topic is for copyright, you don't need to register to IPOFIL or National Library for you to be protected. You are automatically protected once you put your ideas into writing or documenting them. Copyrights are applied to you and to other people, so always cite your work to prevent from copyright infringement. So we will now move to our next speaker, but before that, I would like to acknowledge those who just tuned in. Welcome. This is our fourth series of Dr. Mariano Lau webinar, and the topic of which is the intellectual property and data privacy in online education. Let me remind our audience and listeners to please write down your questions in the chat box or in the Q&A tab at the bottom of your screen if you have some concerns or queries about the topic. We will have an open forum portion at the last part of the webinar. Okay, so our next speaker is Dr. Peter C. He is an associate professor from the Department of Philosophy, University of the Philippines, Diliman. He is a chairman in the Privacy Expert Group, eHealth, Department of Health, DOH, and DOST. He is a member and a lecturer from the Philippine Health Research Ethics Board and Committee on Information Dissemination, Training, and Advocacy. He is also a chair in ad hoc committee in Open Data, University of the Philippines, Diliman. He is a program director from 2011 to 2014 in the Ethical, Legal, Social Issues Program Philippine Genome Center. He has been research consultant in public assessment of water services, a National Engineering Center, research fellow at the UP Center for Integrative and Development Studies, a recipient of several international publication awards from the University of the Philippines, and a referee of various journals. Let me give this opportunity to give the slide or give the video to Dr. Peter C. So good afternoon, Doctor C.
Uh, Good afternoon. Mayang hapon sa tanan. Thank you for having me here today. So, as you can see, the topic I'm going to essay on would be privacy in online education. When I deal with privacy, this usually takes hours. Obviously, we don't have hours. The workshops I conduct on privacy would take days, and obviously, again, we don't have days. So I'll focus on a very narrow concern, online education, and probably even sharpen the focus on, say, cheating. So what I'm going to do is highlight to you how relevant the topic is. We're all shifting to online learning, and recently this has raised alarms to many observers. So this is just a few months ago. They did an online protest because the Australian National University is shifting to online learning, and it's going to use a proctoring system, which is also adopted elsewhere in North America and Europe. But then the students, some anyway, are not having it. Just to put it in context, Australian education is the third largest export of Australia, so it's a big deal. Uh, Chinese people come in droves in Australia, partly for tourism, but also for education. The Philippines is what you call the diversity market. Filipinos go to Australia for education also. So it's a big deal. We focus on this. So I'll come back to that later on. But for now, let me just raise a few points about the carrot aspect of privacy, because when I hear colleagues discuss privacy, it's almost always on the punitive side, on the stick side. But there is an argument to be made that it makes good business sense for institutions like SILLIMAN University to practice privacy or to take to heart privacy because it has good return on investment. It's a very good way of managing risk, and most especially when we come to education, because education is a highly regulated market. So putting in privacy management is something that makes a lot of sense. So in terms of ROI, as a matter of fact, this is based on the recent Cisco 2020 data privacy benchmark study. They're saying that if you put in $1 or a peso for privacy investment, the return is twice that amount, right? 47% of the businesses in a way. So there's always an argument on the side of return, right? So more specifically, you may want to look at certain aspects of how privacy may impact you positively. You will reduce sales delay if you're in business. This is also something that is applicable to education. We all sell something. We mitigate losses. We enable flexibility in our organization. We are able to innovate well because we have access to data that are really premium data. We achieve operational efficiency if we have sufficient rights to those data sets. We have we make ourselves attractive to investors, or to in the case of SILLIMAN University, to alumni, because we make good practice. We do best practice, and of course we endear our students. They become more loyal to us because we respect them. The other side of the concern, the other would be on the education itself. We are interested in learner success, but this is where things get dicey, because when you do this, you will have to what may be in a superficial sense violate the students' data, because you will have to, if you're not asking permission anyway, you will have to look at a lot of analytics. Some of the data there, they may not necessarily be interested in sharing, or they forget that they have signed off for the school to look into. We also have to look at the data of utilization. For instance, how many are users of library resources, because if you go online, they're no longer going physically to Silliman University Library. You will be required to have online access to online journals. They are very expensive. They run up to millions. And so you would want to see that these things are utilized well. So you have to check who are accessing these resources. This is getting to be a gray area these days. The learning management system, for instance, will have to help the university and the teachers predict which students are likely going to drop out or not do well. And this early on. So if there are students in the audience, feel free to tell us whether you feel comfortable with this, because this is not going away anytime soon. We'll be looking into you guys. The learning management system is a big brother system. We want to predict whether you want to stay or not, or you're likely to succeed in an online learning. We also would like to see your help-seeking behavior. So if you're down, if you're not doing well, are you the type who will seek out the guidance office, for instance? Are you the type who will reach out to your faculty advisor, to the teacher? And so more importantly also, is the intervention impacting you well? No? Is it effective? So we're looking at this. Now, the learner's dashboard can be very intrusive. Now we are looking at hours, minutes, which materials you have touched, how long did you stay, the things you check out. It's a very big brother kind of system, especially learning management system. And then we'll have real-time analytics. No? So if you take an exam, for instance, are you saying who you are? Are you really who you are, saying you are when you take an online exam, or is your brother taking the exam? And of course, the related point on exams, are exams online have the kind of integrity when we see exam being proctored in a room, for instance, now with proctors watching over you. All right. So these considerations. Now, so let me just walk you through first some of the key definitions of privacy. So if you check out the privacy law, there is no straightforward definition of privacy, always alluding to. But let me just point out some at least three key definitions with you, historical ones. No? So all the way back to 1890 and the work of Warren Brandeis, in Harvard Law Review, the privacy, privacy is defined as the right to be alone. No? And that is not difficult to understand. We want to be let alone. You don't want people to be calling you, offering insurance while you're eating, okay, or while dating. The other definition would be the decisional type. You don't want state intrusions into your life. You don't want the state to decide for you how many children you should have, how you should reproduce, or how are you going to die. So that's decisional privacy. There's also the informational nature, probably most important to us this afternoon. And the idea is that we want to have a control, if not full control, of the kind of information about ourselves out there, when, how, and to what extent this information should be shared. So it'll be interesting to note that one of the Renaissance eras in history of privacy would be the 1960s. There was so much privacy research going on. But so I have given you three definitions: the right to be let alone, decisional privacy, informational privacy. All this would eventually be about data, actually. So everything these days is about data. So we are interested in the final form we call data, hence data privacy, and that is what is being regulated. So this is the slide from the National Privacy Commission. So when you say privacy right or privacy rights, is actually a bundle of rights, including the right to be informed, okay, that your data is being collected, the nature of collection, and so on. The right to access. So if the students are sharing their data, they're supposed to be able to access such data later on. So this has serious implications to universities or to online learning. The right to object. If there's an information that needs correction, it has to be objected to. The right to erasure or blocking. So certain data data fields might need to be erased. No, recently, if you're familiar with European law, there is this Spanish case was lodged before the EU about a person demanding his right to be forgotten. And for those of you who are in love, probably this is also something you can demand from your excess. The right to damages, right? So right to damage would be if certain data would lead to financial fraud, and you see that the accountability lies with Silliman University, then you can sue Silliman University or my university for that matter. The right to file a complaint, no, there has to be a way um, of elevating your complaints to the highest levels, no. The right to rectify related to erasure and to access. You will have to be able to correct certain data, right? And then the right to data portability. This is important in that if you're no longer trusting the institution that has your data set, you can demand that it be shared with you, it be shared in a form that is easy for you to carry around, all right, or to download, right? And this is probably something that you can pass on to your children as some kind of heritage. And there are limits to all of this. Unfortunately, I don't have the opportunity, the time to discuss all this, but just to note for now that all your rights have limits, and they need to be balanced with other rights. In the case, for instance, of online learning, the students are essentially giving implicitly at least teachers the right to pry into your lives because they want to understand you, right? So another important definition is personal information, and this is the very subject of data privacy. And personal information has to do with identifiers, the things that would enable other people to identify us. And there's a bunch of this. No, so these are the so-called HIPAA identifiers, 18 of them: your name, address, telephone, URL, biometrics, no, medical records. So even educational records, no. When the last time you took the test, no, that is included. Now photos, the profile pic you upload into your LMS. Understand Silliman has its own learning management system, so the photos you upload there would be identifiers. Now all these things would be in the hands of the information controller. If that would be the highest office of an institution. No? So we identify controllers per, say, business registration, for instance. In the case of Silliman University, probably the president or its board. The idea is that this is the person or the entity with direct hand on the processing of information. Processing meaning copying, collecting, deleting, disposing. Anything that is being done on data would be processing. So the controller is the one giving orders. Now, if you are working in a computer center or in some office, you could just be a processor. And if you're clear about your task, you know, and then there is an explicit order for you to do certain things with data, the liability may not necessarily be yours. It can be passed on all the way up to the controller, provided that you can prove that you're just following orders. So this could be in the purview of control, again, the definition I gave earlier. However, if you are going rogue, all right, and then for instance, you copy the the list of students with their phone numbers, and then take them home, all right, and in the process, you lost your laptop or the USB drive, then you could be liable because it may not necessarily be proven that it's part of your job to take away that such data set home, all right? So another potential confusion is the overlap between data privacy and information security or data security. Now, for some people, they tend to conflate the two, but strictly speaking, they are different. There's only a narrow intersection where data privacy and information security would intersect. would overlap. And this is on the issue of availability. You want your online data for online learning always there, right? You hate it when your learning management system is down. You hate it when anybody can just look into your data. That would be confidentiality. That you're having a hard time in your Chem 11 class. You don't want your janitor to know this, right? Or there's integrity of your data. You would want your grade to be as it is. No, so if your teacher gave you a 4 or 95, it should remain 95, and no one in the dean's office could subtract or add to that. No, so these things would be overlapping with information security, but privacy protection really has to do with these following points, no themes. One is transparency. How are the rules evolved? How are the rules applied? What are the rules to begin with? Are the data being collected according to a legitimate purpose? No, is this something that is aligned with the university charter, with the mandate of educating you? So if the teacher has a legitimate purpose for collecting the data, why is he or she asking you for your PIN number? Just kidding. Proportionality. So if the purpose is to educate you, why is the teacher asking for information via LMS uh, on on the things you sell, for instance? No, if you're having a racket online, no. Limited use, so that if it is the data set being used solely for the purpose of education, or it's also shared by something else. Now, is for instance the institution selling insurance, for instance, no, or selling other things, no? Is it being disclosed to other people when you signed up for your LMS for online learning? You know that it's just for the purpose of education. Why is it being used now for? Why is it someone has that? What later on you may realize that it's being shared with some sponsors abroad without your knowledge, right? Or you already graduated from SILLIMAN, but you still get notifications, no, from your learning management system. No, why is the data still there? No, data minimization related to limited use. You are not supposed, and proportionality. You're not supposed to have so many data that are no longer needed. They're supposed to be accurate, and more importantly, did you consent to such collection of data? Do you have access? So all these things is better determined through a process called privacy impact assessment. This is something that is expected, standard already for many institutions. When I do privacy impact assessment, it is going to be in a secluded place where important officers are there in the institution, and it's going to be a 2-day exercise, and that's more or less a very thorough, moderately thorough exercise for institutions, no? So it has to be determined through a process called privacy impact assessment. So let me just zero in on consent for now. I cannot cover all those in detail, all those principles in detail, but then there's a sea change, I would say, with the arrival of GDPR 2018, and this has become a de facto standard all over the world. So for another time, I have GDPR jokes. So if you visit your colleagues in Australia, they're talking about what Europe is so remote from us. Why is it that it's being imposed on us? But at any rate, that's the power of de facto standard. No, so the idea is that consent is even more pronounced in current regulations, especially global standards. You can no longer assume that if the student is silent, he's agreeing with you. You can no longer just ask people to just pre-tick those boxes, and if he disagrees, he would untick those boxes. If he's not, if you're not hearing from them, you assume that they agree with you. This is no longer the case. No, so it has to be active. and the consent has to be crafted or fashioned in clear and plain language. Which is really tough, no, in some situations where you're pressed for time, no. So you will have to look at the entire information cycle to be able to be and to be thorough in the way you address privacy issues in your institution, whether online learning or something else. You will have to look at your collection. What is the extent necessary to collect, hold the personal information in order to carry out your functions? So if you're doing library work, why are you collecting information for Silliman University Church? So are you collecting for a particular legitimate purpose? No. Number two, handling, using, organizing, sharing personal information requires overall data and privacy management plan. Do we have a plan in place? Is this something that is already institutionalized or still being done on an ad hoc basis? Do we have a risk assessment exercise? Are we looking at processes? And these are the specific areas we need to look into, whether online learning or something else. You look at processes, you look at systems, you look at programs, projects, dealing with personal data, and it can be a lot, no? Enormous amount of data. Now, just to give you an idea, if there are administrators in the university in the audience, if I may ask, do you have any idea how many collection forms do we use in the university? So in my unscientific sampling in this kind of exercise, people would answer hundreds and even lower figures, tens, 20s. But in fact, now if you really have to be thorough, in some institutions, they run up to thousands. Now, a middle-sized hospital, for instance, in my experience, would have about 1,500 forms collecting personal information. And many of these forms are really outdated, if not offensive, right? So they have not been revised since the 1970s. So if you take a look at our forms, see if they are irrelevant, if they are not over collecting, no? And this is something that would be factored in when you do risk analysis. We also have to take a look at protection of our data sets. I think I don't have to belabor the obvious here, but then it can be a field on its own as well. And then finally, disposal. If your collection for online learning is only X number of years after student graduation, then you do so because you might be liable, right, for keeping information that is no longer authorized. No? So there's all sorts of things that can happen, but we're particularly interested in breaches, no? In security breaches. So this is how the National Privacy Commission defined breach, unlawful and unauthorized processing of personal information. So if you are in a registrar's office, for instance, no, and there is the analogy here in the medical field, medical records. The medical records officer is having his family come over, and his children are browsing through patient records. That is an obvious breach. If you are the registrar and your family or your children are able to access student records, that is an obvious breach. And there could be more, no, on availability, integrity, and confidentiality. So on availability, for instance, is the data available as it is supposed to be, or there's already a loss that you don't know, or you know but are not, but you know but you're not disclosing, you're concealing. And that would aggravate the situation actually, because concealment in law would even trigger stiffer penalty. Now, and I'm not, as I said, I'm going to underemphasize the scary part of the law, but then the idea is that you better take this seriously, because it's actually fine and imprisonment. It's not or. And fine for data process controllers would be up to millions, 4-5 million, and imprisonment up to 6 years or thereabout. So it depends on the gravity of the situation of the breach. So it's pretty serious actually. No? Integrity breach. in the Philippines, we're familiar with this. Some of you in the audience might have experienced becoming instant millionaires from the BPI snafu, where people saw millions in their savings. It turned out it was an integrity breach on the part of BPI. Confidentiality breach would be related to one of the examples I gave you earlier. When people who are not authorized to have access to data are suddenly having such kind of access. So we'll now come to specifics in online learning. As I said, the learning management system, which is the contact point where the rubber meets the road in online learning. All schools are pressured to get some kind of learning management systems. So the more advanced ones would have learner tracker. If you are a student and you only see what we see as teachers, I mean, if you can only see what you see as teachers, it's pretty invasive actually. We know where you are, we know what the things you're watching. But then again, this is really in the spirit of trying to educate you that there is good intention, and as a matter of fact, you have given us the permission, the consent to access your data for the purpose of educating you online. So there's all sorts of dashboards, very detailed, what we can see with you guys about you. And there's this also matter of predictions I have hinted at you guys. Now, so you're not yet, you're only quarter of a semester, but we can, in a sense, already judge whether you're going to thrive in this online course. And it's not a pejorative actually, because we want, as teachers, we want to be able to help you. So we want to have some kind of a tool that will help us help those first, no, or who are in needing the most, no, of our help, no. So there's all sorts of indicators there. For instance, about 40 of them we can, at least according to the algorithm, and you have to tell me how you feel about this algorithm, in a sense, judging you. There are about a little over 40 indicators whether you guys are going to drop out. Now, we want to have an early warning system because we want to be able to help our students. In our university, we have this slogan of sorts, no student left behind. And this is only, this is especially relevant when we have such kind of dashboard, when we have indicators. Now, the question is, at least on the conceptual aspect of this, how accurate are these indicators to be able to predict your behavior? You feel aggrieved as a student that you're, in a sense, being judged early on. So for us teachers, we know that exam is not necessarily the same as assessment. There's all sorts of tools we can use, we can deploy in assessing our students. We know that test is not, I'm sorry, it's not education. I forgot to do the slash. It's not education, nor is education synonymous with learning in its sense. And we want to maintain exam integrity, no? And so there's all sorts of tools and measures being used to deploy to counter cheating, no? And one of these is online proctored exam. Maybe this is not yet in the vogue in the Philippines, but it's there. No, full disclosure, there are many competing services out there. Full disclosure, I don't want to sneak this in, but the reason I brought up Proctorial because I'm the one I do consulting for them. But then the idea is not, I'm not selling this to you, but the idea is to have a really detailed look on the kind of intrusions into your personal lives is being done with Proctorial. So, or any system for proctoring online exams. So if you do consulting for such kind of service, you would want to know what are the ways out there that people would cheat. And there's this whole bunch of discussions in Quora and elsewhere that, as a matter of fact, people have almost perfected the art of cheating online. And this is really the misgivings of some teachers when they go online. Of course, we cannot do in-person teaching these days because of the pandemic, and so we're forced to go online. But then it's not a happy place entirely. No, there's this prospect of cheating, and if you're not ready, you're not armed, you're not confident to do online exam or to give online exam, most likely you'll be cheated on. All right, so there's all sorts of techniques that people would use to cheat. No, so you would want to, as this is now on the teaching side, on the service delivery side. Now, if I give you an exam, I will give you a privacy notice. And I want you to pay attention to this kind of privacy notice because, well, for one, it's a part of the new normal now that when we do things online or elsewhere, we have to issue privacy notice. So if you walk in our corridors in our school, pre-pandemic, every corner has a privacy notice that you are being observed by a CCTV. I don't know if you're already doing that in SILLIMAN or maybe in some other schools, but in our university, we cannot mount a CCTV without a privacy notice. The same with online learning. So if you collect data, if you do specially intrusive activities, you will tell people that, hey, as a matter of fact, we are observing you. No? And the idea is that you would want to have these tools necessary to counter cheating in an exam. For instance, right now I'm looking at the camera. What if I look at on, say, certain angle beyond the pixels of the screen? Meaning the camera, at least if you're on proctorial, is observing your eye movement, your eyeballs. You're observing your gaze. That if you're looking at this side, this angle of view, this kind of gaze, most likely there's going to be another screen there, probably your cell phone or another table, where you are researching the exam or looking for answer, or probably some help with your father, with your mother, uh, your friend, your kuya, who is giving answers to you when you take an online exam. And so for exam administrators, I need to know where you are looking, right? So I need to track your eye movement. So these things, no? So are you inserting a USB device? Are you doing other things? No, do you have a second device in the room, another laptop maybe, or probably you're projecting the answers or the screen also simultaneously through TV, right? Or are you doing sign language to get the exam? So I want all these details to be recorded. And as a teacher, I will not just be accusing you that you are cheating. I want to be able to show to the disciplinary board that you are in fact cheating. And so it's going to be full on crazy documentation for me that you are cheating, right? Or I want to know if there is someone else logged into your account who is in maybe Korea answering the exam for you, all right? So these considerations. So for us teachers, we want to deploy comprehensive measures now to deal with cheating. It's not just purely technical. We want to do exam lockdown, for instance. You don't want students to be able to Google or to click on links. But you would want to approach this in an organizational way. There is going to be freshman orientation where you orient people that they're not supposed to be cheating because they're in a Christian university, for instance. Or methodological, you want your creativity in the way you ask questions, no? Questions that are not easily prone to cheating, no? Or you would want to look at behavioral. Now, there's this book by a behavioral economist on why people cheat, Dan Ariely. I suggest you take a look at that. Certain measures, behavioral measures may help or could help. Believe you me, even atheists, if you make them swear on the Bible, they tend to be less likely to cheat, even if they don't believe in God. The very act of swearing of making a promise at the start of an activity not to cheat reduces the determination of people to cheat. So all these things may figure into into the measures we have. Now, finally, let me just wrap up this presentation so we can do more via Q&A. Um, uh, we just have to make sure for teachers and institutions out there or participating also here to go for to ensure rather that our activities have a legitimate purpose. Even online learning has a legitimate purpose, and it's clear to our constituents, especially students. And would suggest that to do this, you will have to over communicate. So it's going to be in the student manual. It's going to be in the orientation. It's going to be in the login page. It's going to be when they sign up for an exam or they enter into exam room. And all this could be part of a data governance accountability framework, which I'm happy to discuss much maybe probably later. No? And then always maintain proportionality, that we are doing data collection, we're doing quote unquote surveillance only to the extent necessary, and we don't overdo it. So I'll stop here, and we probably can do more Q&A. Thank you for having me again.
Okay, thank you for that insightful sharing of knowledge and experience, Dr. C. I know that our listeners are now taking down notes so that they can apply it immediately in their online classes when the class starts in August. So, as my takeaway from the topic, I have learned so many things, but the one thing that got stuck in my head is uh, we have the right to be alone. Be mindful of your data. Where does it go? How is it collected? And the purpose of such collection. I also learned that when we deliver exams, it's good practice to have a privacy notice or a policy. Now, let's go to our open forum portion of this webinar. For those who have not posted their question yet, you can still post it in the Q&A tab or at the chat at the bottom of your screen. You can also raise your hand using your raise hand feature, and we will open your microphone. Okay, let's start. Are we ready, Dr. C and Attorney Ganier? Are we ready? So let me check first some questions. We have here from Rosemar Banyas Piniga. You're raising your hand. Can we open her mic? Okay. Rosemar, are you there?
Yes, sir. Good afternoon.
Okay.
Do you hear me,
What's your
sir?
question? Yes, we can hear you. What's your question?
Yeah. Sir, my question is with regards to IPOPL or IPR. Let's say, for example, if my dissertation, can I apply IPR?
Okay. I think Attorney Ganier can answer
Yes.
that.
Yes,
Attorney Ganier.
Yes.
your dissertation is considered as a copyrightable work. So after you have written your dissertation, automatically you already have intellectual property rights over there, over that property. So no need for you to go to the intellectual property office for you to register copyrights over your dissertation. As long as you have written, it's already in written form, you've already published it. It's already even if you have not published it yet, even if it's still just a manuscript, you already have intellectual property rights over that. Nobody can copy it or claim it to be or claim it to be theirs because you are the author of it. So automatically, upon creation, it's upon creation that you have intellectual property rights over the work, and anyone who copies or reproduces your manuscript of your dissertation without your permission is already committing copyright infringement over that.
Okay. Did Sir Attorney
Yes,
Ganier answer that?
is my answer. Did that answer your question? If you have any follow-up questions, I'd be welcome to answer them.
Oh, okay. Okay. So I think in the context, let me just ask this question to both of you, no? To Sir Peter and Sir Gilbert. What's the difference between plagiarism and copyright infringement? When does a plagiarism become a copyright infringement? I think that's the usual question.
May I answer that? So
Yes, yes,
plagiarism,
yes.
so plagiarism is a form of copyright infringement. Um, there are many types of copyright infringement. For example, when you make hundreds of copies of a book and then you sell it for profit, that's a form of copyright infringement. Plagiarism is a specific type of copyright infringement in that you are claiming to be the author of a particular copyrightable work, or you quote a copyrightable work without proper attribution or citation. So there are many different types of copyright infringement, and plagiarism is just one type of copyright infringement. And specifically, like I said, that's when you represent to be the owner or author of a particular article or portion of an article or journal article, and you fail to attribute that article. Sometimes when you copy paste, for example, an article, and you don't put it in open or closed quotations, and you don't cite the author, and many students unfortunately do that when they try to hurriedly make an essay to be passed in the following day. That's plagiarism, and that's a specific type of copyright infringement.
Okay. Peter, Sir Peter, do you have anything to add to that one? Nothing? Okay, so let's go to the topic about data privacy. I will address this one to Dr. Peter. What can you do if there is a privacy breach, data privacy breach? Who do we go to?
I'm assuming these are students. You, of course, try to address this with the institution that is responsible for the breach. But if the institution is not responding, you can elevate your complaint to the National Privacy Commission. The institution is supposed to report to the National Privacy Commission the breach within I think 72 hours upon knowledge. Now take note, very crucial distinction, upon knowledge of the breach. No, so yeah.
Okay, thank you for that. Another one from an anonymous attendee, Sir Ganier. So it's addressed to Attorney Ganier. I have a website for my photography hobby. Is it enough to put a watermark in my photos, or I need to be copyrighted?
Yes, I'm also a photography hobbyist, but I've already haven't practiced that hobby for a long time. So photographs are a type of copyrightable works. So the moment that you take a picture of something and then you publish it, and you post it, you are actually already protected by copyright, even whether or not you put a watermark in those photos, as long as you can prove that you're really the one who took those photos. Now, photographs are a special problem area in intellectual property, especially in this digital age, because they're very easily shareable. And once you post a photograph on Facebook, for example, or on your website, you allow, and it's easily, it can be shared or copied, and it's very difficult to track where those copies go. So generally, what photographers do when they create their own website is they have a copyright notice reserving copyrights over those photographs. Now, watermarks are another thing that you can do. When you put a watermark in your photos, you're basically making that copyright notice as well. But the thing is, it doesn't mean that the photos are no longer shareable or reproducible anymore. What happens is that although you are protected by copyright, the tracking of the violation makes it difficult to do. So whether or not, if the question is, are you already copyrighted by the fact of posting it on your website or Facebook? Yes, definitely. The photograph is already copyrighted right away. But the enforcement of your copyright or bringing someone to court for reproducing your photographs without attributing it to you, that becomes a more difficult thing to do, especially in this digital age. It's very easy to copy and paste, or especially it's very easy to share shared photos, images, and even videos. So the question here is it enough to put watermark in my photos, or do I need it to be copyrighted? You don't even have to watermark it. As long as you can prove that the photos came from your camera and you were the one who used the camera when you took that photo, it's already copyrighted right away. You don't need to go to any government agency to do that. Although you are actually voluntarily allowed, you're allowed to voluntarily go to the intellectual property office to register to submit a record of your photo to the intellectual property office. But that doesn't actually add any more protection than any other than you would otherwise the copyright exists the moment of creation of the copyrightable work. Maybe the only benefit of submitting a copy to the copyright division of the intellectual property office is that it might be easier for purposes of evidence to prove that you really are the owner of that photograph. Okay, so I think.
Okay, is that
Dr.
I think.
Yeah, I think if they have a follow-up question, I'd answer that. If Dr. C also would like to add something.
I'm good.
So the next one, I think this is addressed to Dr. C. I have concern about the big brother character that can potentially leave a bad taste to the experience of the online distance learning, not just for the student, but also for the teachers. How can this be addressed?
Thank you for that question. It's at the core of online learning. I think it has to be addressed in a multifaceted way. It is going to be a balancing act. I might have exaggerated the big brother aspect of this, but if we go forward with just the big brother approach, it's not sustainable. There is cost to it. Just to give you an idea, to monitor an hour exam for a student, you need at least 1 gigabytes of data. And so if it's a 3-hour exam, 3 or 4 gigabytes times say 30 students, that's not cheap. So you would want to balance that with other things like trust. You would want to put your students in a track that they can be more trustworthy. So my favorite example is that if you are in a relationship and you don't trust your boyfriend, you spend a lot because you will have to monitor his cell phone. You hire a private detective to see if your girlfriend has another girlfriend. But if you trust him or her, it's actually very cost effective because all you need is just his or her word, right? So the same with online learning. If you trust your students, if you trust the teachers that they're not going to share your data, it's so much cost effective and more congenial, no? And it doesn't, in that sense, doesn't leave a bad taste in the mouth.
Okay, thank you. Now, the next one, I have here, what are some guidelines and tips in making video conferencing when it comes to IP and data privacy? I think both of you can answer this one. What are the tips? Because basically we're now in video conferencing and so on. Let's start with Dr. C. Can you give us some tips and guidelines on making video conferencing?
I don't know what you're trying to prevent. There's this book by Val Haryan, Information Management, because I think we have a fundamental misunderstanding on the nature of digital goods. All right. We think of protecting as in not sharing, but if it's not being shared, you also diminish the value, or at least not increase the value. The more data is shared, the more it's valuable if more people find that useful. And so rather than looking at management, or as in protection, as in keeping it in your baul, I would encourage people to look into the prospect of management, okay, and understand the nature of digital goods. Now, video conferencing, if it's meant to be private, then keep it private. Do not record it.
Okay.
But if it's going to be recorded, it's going to be, there is a potential it's going to be shared. So you try to be proactive about it, like be decent, so that it's not going to come back and bite you in the neck later on. Yeah.
Something to add, Attorney Ganier?
Yeah, I share the sentiment of Dr. C. I think as more public spaces are created in the digital age, I think the more vigilant we should be as well in terms of what we share on the internet. So I think that's you are the front line of your own privacy, and as well as your own rights, even when it comes to intellectual property. So if you have manuscripts that are not yet published, and you want to make sure that nobody that you can't trust will be able to copy and reproduce it and profit off it, then better not to share it to anyone that you don't trust. So it's really, the thing is, when it comes to the law, my personal legal philosophy is that the law is not the answer to all problems that society faces. Sometimes decisions at the personal level sometimes problems are solved at the personal level or the decisional level of the person. So my tip really is, if you want to protect your intellectual property rights in video conferencing or even in any other kind of forum, don't share it. That's the most. If you don't shoot the ball, it will never go in the net, right? So that's one way of looking at it. But I also share that there's a counterpoint that Dr. C also said, that if you don't share knowledge, if you don't share intellectual property, the value of it also diminishes. Or you don't want to, you want to share the whole. That's really the balancing act of intellectual property law. There's a benefit to the public if intellectual property is shared, but at the same time, you also want to protect the rights of the person who came up with the idea or came up with a particular intellectual property. So for you at the personal level, also you have that decisional. You have to make that decision of balancing also. You care more about the economic incentive of your intellectual property, which is fine, definitely fine. There's nothing wrong with being with looking at it that way. Then protect it as much as you can. Don't share it. If you think that society can benefit it for it more, even at the risk of your rights being unprotected, then maybe you can share it. It's really about it's really a decisional thing.
Okay, so another one from Rosemar Pinaga. Sir C, what about Google Form? Is there possibility that the student can cheat on Google Form?
Uh, I'm not sure what's the context of this question, Rosmar, but if you're conducting your exams in Google Form, very much a distinct possibility that the students can teach because a Google account can be shared. If you're doing data collection in a more or less secure way, maybe you can use Kubu Toolbox is an alternative platform by the United Nations. Or if you're conducting exam for an online class, I suggest you put them in an LMS with an exam lockdown capability. So there are technical solutions out there that can be used to prevent cheating. But as I said, cheating is the final act of desperation, or maybe the student doesn't want to learn to begin with, and he just want to you want your course to be something to be done and over with, no? So not interested in learning at all, but you don't want that. So you would want to catch him early, uh, uh, engage him early, so that the testing is just an icing on the cake, so to speak. No? Yeah.
Okay, thank you. Uh, we have one question from Facebook. It's from May May. Uh, Under the fair use principle, is lib is library allowed to provide the scanned copy of entire printed book to the student and faculty of the university? We have this electronic document delivery service in the library to protect copyright. We are planning to grant access to student and faculty the 10% of the scanned copy of the printed book. So basically the question here is, there are, in fair use principle, is it allowed to photocopy the entire book?
Oh, um, actually, under the Intellectual Property Code, there are instances when libraries, dealing specifically with libraries, the Intellectual Property Code explicitly states that libraries can make digital copies of books if, for example, the books are rare or they're already in danger of being destroyed or lost. Libraries are allowed to make digital copies of those. So there's no question about the library making a digital copy. I think the second part of the question is the more interesting part, which is whether or not the library can provide access to the digital copy made by the library under the fair use principle. So if you go back to fair use, as long as the requesting party has a legitimate scholarly educational purpose for requesting a copy of the book, then there's no problem with the library providing that. But I think some um, some safety nets that the library can impose is maybe um, like require the requesting party to fill up a request form. And in that request form, the requesting party should state why they are requesting that particular book or journal, for what purpose they're using it. And ideally, as much as possible, if they can also identify which portion of the book they are going to use for their scholarly or academic activity, and just to make sure, in order to protect also the requesting party under the fair use principle, that when they access the property, it's really for a legitimate fair use purpose. At the same time, for the library, the fair use principle really, the main goal of the fair use principle is really to to protect more the economic rights of the author. So the reason why the fair use principle is a limitation on copyright is that the um, people are allowed to reproduce copyrighted works as long as it does not hurt the economic or prospective economic benefits that the author is expecting from the copyrighted work. So as long as the library doesn't charge, exorbitant amounts of money for the copies, maybe they can charge just for, as a matter of maybe the labor cost or for the administration cost of looking for the book. Maybe they can charge that, but definitely as long as the library does not profit off of that, then it is a legitimate or fair use of the copyrighted work. So I think maybe the question is from Facebook. Maybe they can find a way to respond to the answer.
I think we have two more questions. Dr. C, this is a follow-up question. Dr. C, you mentioned about analytics and algorithm being used to monitor. Should this be a concern if the employment of a big brother concept come into the picture?
It depends on the balancing you deploy in an LMS, because there is an argument to be made that the teacher needs certain tools, algorithms included, to be able to proactively help the students. The students, on the other hand, can say, "I'm okay. Don't bother helping me. I'll be on my own. Do not predict whether I'm going to succeed or not." But there is some kind of soft paternalism for some teachers. Let me explain this rather lengthily. So if you cross a bridge, you pass through a village and say, "Oh, I'm going to cross that bridge," and the villagers would say, "Don't cross it because it's broken. You're gonna fall. You're gonna die." So soft paternalism would just be informational. I will just persuade you not to cross. But then hard paternalism is, I'm going to restrain you, prevent you from crossing that bridge. So an analogy can be made with LMS. There is some kind of soft paternalism there. I will persuade my student to be acting certain ways, so they will pass the course, they will succeed. But then the student can always say, "Don't bother me. I don't want you to be observing me." But it depends now on how you're going to have the conversation develop.
Okay, thank you for that. I think we have one last, I think this is addressed still to Dr. C. Can a study be made on the time involved in taking an examination or assessment such that for an exam, a certain amount of time would be given to avoid cheating? Say for an exam to be done in an hour, the time given will only be an hour, not more.
These are the options your standard in LMS can have. Keep the exam according to schedule. It's gonna start at 7:01. It's gonna end at 8 sharp. These things can be a matter of settings in standard LMS. I do that myself. But then cheating is really something. Cheating is a very complex behavior, actually. There is an incentive to cheat, but there's also this idea of power. So it depends on how you want to play it. The LMS can help you, but then I would really advise our teachers not to put students in a situation where they are forced to cheat. Baka naman sobrang pahirap yung exam mo, it's not really getting to the objectives, helping the students learn, but more like, demonstrating that you're only next to God. So it depends on how you want to play education, because the bottom line really is the students should be learning whether there's going to be an exam or not.
Okay, thank you for that, Dr. C. I think those are the questions. I see no more. Okay, so I think those are the questions for now. I hope that all of the questions have been answered. Thank you again, Dr. C and Attorney Ganier. Also, thank you for the people who have gave their very good questions in the Q&A tab. Thank you for those. You can still post your questions in Facebook if you still have some lingering queries. Furthermore, if you have some questions concerning about the topic, you can reach out to our speakers. They will gladly share their knowledge to you. Sir Ganier here in SILLIMAN, so you can go to the College of Law and try to approach Attorney Ganier if you have questions about your copyrights. Okay, thank you for that. Now, at this point, we would like to give the certificate of recognition to our speakers. Let me read the citation. SILLIMAN University presents this certificate of recognition to Attorney Gilbert Agustin Ganier for sharing his valuable knowledge as a guest speaker during the 4th series of the Dr. Mariano Lau webinar series with the topic Intellectual Property and Data Privacy in Online Education, which was held on the 25th of July 2020 via Zoom online. Signed here is Dave E. Marshall, PhD, the project leader of Dr. Mariano Lau ICI Laboratory. Same recognition goes to Dr. Peter A.C. Same citation for sharing their valuable knowledge as a guest speaker here in the 4th series of the webinar. So, to bring, thanks again, Dr. C and Attorney Ganier. So to bring us to a conclusion, we have learned a lot today from our speakers. We learned about intellectual property. We learned about data privacy. As an educator, as a student, and as a parent, we should be mindful of ours and other people's intellectual property, data, and information. Especially we are now delivering our topics and education online. We have the rights to these intangible properties or assets, and we should respect them and respect others. So we have a great time in this webinar, but before we go, we would like to ask our listeners and audience to please take time to answer the evaluations shown in the screen or posted in the chat box. This will serve as your participation in this webinar, and so that we can give you your certification. Thanks again, Dr. C and Attorney Ganier, for sharing not only your knowledge and experience in this area, but also your time. As an announcement, we will have another webinar talk on August 1, the same time. This will be the 5th series, and the topic is about asynchronous learning. So I hope we can see each other again there. So once again, thank you to our speakers for giving us a very informative topic about intellectual property and data privacy. This is Clint Ian Austero, your moderator for today. Thank you and have a pleasant rest of the day.